It is my pleasure to introduce David Silver. I have been fortunate enough to work with Dave quite a bit in the last 6 to 9 months on a variety of some normal and some strange projects at my particular building. And I am able to say with great confidence, you're in very good hands today. David is a shareholder at Perrier, Silver and Taylor, which is a law firm that has been advising homeowner and community associations for over 20 years. He's been providing general legal counsel advice to associations for well over a decade, and also is very active in WSCAI. He's on the business partner committee. He's also a frequent speaker and contributor, and has presented numerous times at Law Day, Made for Managers Day, CA Day, and lots of other events throughout the year, including things like this. And so this is a really great opportunity for everybody. Dave is a hard worker. He tries not to work 24/7, but I can tell that he has answered my emails at obscure hours morning and night, so I'm not sure he's terribly successful in that endeavor. And in his free time, he enjoys skiing, so he's probably one of the people excited about the snowfall that we're currently having. He's also a mountain biker, plays golf, and spends time with his family, including his new puppy, who is named Chuck. And I can assure you, having seen a picture, that Chuck is adorable. So you might even see if he'll share that with you. But Dave, thank you so much for your time, and I'm handing it over to you.
All right. Can everyone hear me? I think we did some troubleshooting before this, but thanks, Heather, Michelle, Tracy, and sponsors. So yeah, I have done, I try to donate time and do some educational things for CAI. WSCAI, and this is my favorite topic. The reason I volunteered is because this is the seminar. These are the topics I like giving or talking about the most, because I think they're the most useful, and I enjoy. All I do is general counsel. All I do is all my firm does. 99% of what my firm does is represent condos and HOAs. So. The one thing that type of legal practice allows me to do that I enjoy the most is the educational part of it. My clients' boards are usually non-professional directors, folks who have day jobs, or they're not professional board members on corporate boards. They're doing this for the first time. They're doing this for the good of their community and their friends and neighbors, and so it's gratifying to me to be able to educate on and talk about these topics, because again, board duties and governing documents, this is sort of adapted from a seminar that I've given, which is just simply board basics. Board duties and governing documents I consider to be simply the board basics, and so we're going to talk about the basics today, and I really think that they're the foundation of what a director needs to know in order to do all of the particular things that you need to do, hold meetings. And Heather talked about the next seminars in this series. I think there's one on insurance. Yeah, I mean, to understand insurance, fundamentally, you're going to need to understand the things we talk about today. So hopefully today will either be a refresher for some of you on some things, and for others, maybe it'll be a revelation of just how simple the basics can be, or what the bedrock of the decisions you're making. I am a lawyer. I'm not your lawyer. We're not going to create attorney-client privilege today. This is just educational stuff. If you've got particular questions, consult your association's attorney. Maybe that's our firm or someone else. There's quite a few. There's a handful of good association attorneys, really good options around the Washington area. So the basics, like I said, here's what we're going to talk about generally. A director's duty of care. Okay, we're going to talk about the laws that govern associations. And remember, the laws that govern associations are a part of meeting a director's duty of care. Okay, so duty of care, laws that govern associations, governing documents in sort of basic association legal structure, board roles and governance basics, sources of authority, using resolutions, effective meetings. And then my last slide contains some common trouble areas. So let's proceed. All right, board duties. You probably all have heard at one point or another, a duty of care. Most often when you hear duty of care, board members think fiduciary duty. And whoops, okay, sorry. I won't react to every bell that rings. Fiduciary duty, that's the first catchphrase that pops, that comes to mind, right? And so I hear from a lot of directors and even managers sometimes. They say, well, and particularly owners when they're mad about something, say, well, you've breached your fiduciary duty, or, has the board met its fiduciary duty? And I'm here to tell you that directors of community associations do not have a fiduciary duty, okay? There's several levels there's several duties of care under the law. Fiduciary duty is the highest duty. I owe a fiduciary duty to my clients. A trustee of a trust would, I think, owe a fiduciary duty to the beneficiaries, that type of thing. But very generally, duty of care is a legal obligation or responsibility to act in a way that prevents harm to or protects others. You have a duty of care as to someone else, okay? A board has a duty of care to the association. You have a duty to act in the association's best interest. And when I say you, I'm referring to you being directors, because most of the attendees today are directors. Managers, I'm not saying you've got a fiduciary duty to associations, but when I say you, I'm referring to the general you as a director. So again, there's several levels, fiduciary duty being the highest. Now, it used to be that the declarant, the developer of a condominium, for the directors that the declarant appointed after building and while selling units and before transition, those directors had a fiduciary duty, but the regular directors had an ordinary and reasonable care, a duty of ordinary and reasonable care. So I'm getting ahead of myself. Can we think of any examples of a legal duty of care from these bullet points? Lawyers already talked about. Operating a vehicle, if you're driving a vehicle, I think you have a heightened duty of care to pay attention, not to run over people, not to crash your car, not to drink and drive. Pilots, think about a pilot of an airplane. If you're piloting your own airplane compared to a pilot of a 747, certainly they've got a very high duty of care, right? The risk of harm being very high if they ignore the duty of care that they owe. Negligence, you hear the term negligence. Negligence is the failure to use reasonable care, a very basic definition. Okay, let's start getting into some of the specifics. For condominiums, under here, 6434, the Condo Act, and 6432, it says that directors shall govern the association consistent with a duty of care to act in all instances on behalf of the association. The officers and members of the board of directors are required to exercise ordinary and reasonable care. Okay, that doesn't say a fiduciary duty. Now, I'm not harping on that to suggest board members should slack off, but ordinary and reasonable care is the standard. Under WCIOA, officers and board members must exercise the degree of care and loyalty to the association required of an officer or director under 2406, which was one of our nonprofit sets of statutes, 2406. So so WCIOA, that's the new statute, 6490. If you're a WCIOA community, a new condo or a very new HOA, it gives you a reference to where to go to read what your duty of care is. Now, I think it's probably sufficient just to read it, because what happens is when there's big problems, there's lawsuits and then the courts weigh in and say, okay, this particular fact pattern met this duty of care, and you can really get down in the weeds. That's not what I want to do today. What I want to do is focus on the big picture items, and hopefully by reciting to you the simple words of these statutes and focusing you in on them, you can hear them, and just an ordinary, you can just read them, listen to them, and they're not that hard to understand. Ordinary and reasonable care, okay? Again, the word fiduciary is not in there. So I think this is helpful. I don't put this up so that you can memorize it just for a Kiowa condo, but this helps shape how we think about what a director of a community association, what their duty of care is. A director shall discharge the duties of a director, including duties as a member of a committee. So we're talking if a director is on a committee, and an officer with discretionary authority. You're required under this statute, and this is 2406, to discharge that in good faith, with the care an ordinary prudent person in a like position would exercise under similar circumstances, and in a manner the director or officer reasonably believes to be in the best interests of the corporation. So again, I'm not sharing this with you for you to memorize it. I'm sharing these with you to get an idea of the concept behind what should inform your duty of care. And then we're going to get into how to meet it. Okay, but first I want to lay out what the law says. This is continued, and I think it's helpful. Otherwise, I wouldn't bore you with such a packed slide. So it says, in discharging the duties of a director or an officer, a director or officer is entitled to rely on opinions. Can you not hear me? Opinions, reports, or statements, including financial statements and other financial data, if prepared or presented by one or more officers or employees of the corporation, whom the director reasonably believes to be reliable and competent, legal counsel, public accountants, other persons as to matters the director or officer reasonably believes are within the person's professional or expert competence. A director can rely on a committee if you think the committee merits confidence. And you can avoid personal liability if you follow the duties as set out in this section. So let's talk about this just a little bit. What this suggests at a very basic level to me is you just have to use your head. You've got to think about it. I mean, if I come to you and say, I'm the attorney and I know how to fix your HVAC system, I mean, I don't have any experience with that. I think what this says is you've got to exercise some common sense. If something doesn't smell right, you can't overlook something or an issue or advice that you know is faulty. Okay, you've got to use some common sense. But you are entitled as a director to rely on the advice of professionals. And I encourage you to do that. Okay. HOAs. That last piece was generally applicable to talk about concepts, okay, but specifically that was with Kiowa, but generally it applies. Use your common sense, rely on experts. That's good advice across the board, okay? For homeowners associations that are not Kiowa, the directors are required to exercise the degree of care and loyalty required of an officer or director of a corporation under 2403. That's our nonprofit act. Okay, and what that requires is you've got to exercise good business judgment. You have a duty of care and inquiry as an ordinary prudent person in a like position under similar circumstances. So again, that suggests, boiled down to the very basics, you've got to use common sense, right? You need to think about problems, use your head, use common sense. And a duty of care and inquiry, if you don't know something, a duty of inquiry means you've got to investigate. It's not enough just to say, I made a decision. You need to make informed decisions, reasonably informed decisions, okay? I'm trying to give this to you in sort of layman's terms in ways that I think about it, in the ways that I talk to my client board members. It's boils down really to using common sense, being smart, thinking through problems, making informed decisions. Okay. This should tie some of that information together. Duty of care, how do you meet it? In your consideration of issues and work on behalf of the association, think about whether you're acting on behalf of the association in its best interest to meet or further its purposes or goals. Okay? Stay informed. Do your due diligence. As a director, you should do your due diligence. Follow the governing documents. Take advice from professionals, your manager, your attorney, your CPA, your maintenance person, your reserve study person. Avoid conflicts of interest. That seems pretty simple, but I've seen directors get crossways with conflicts of interest. Don't hire your Uncle Jimmy and his crew to replace the roofs. I mean, you'd be surprised what I see. It seems pretty straightforward and simple that you wouldn't hire a family member to work on the association. That would be a conflict. It happens, so be aware of those things. Okay. So I'm shifting gears to laws that govern associations. Are there any questions before I move to the next topic? These are all related topics. Part of a director's ability to exercise due care and reasonable care is knowing what laws apply, which is why these topics all mesh together, and why I talk about them one after the other. Once you hear all the topics, hopefully you'll say, oh, yeah, I see all of these are related. But Walter, I saw that did you have your hand up, sir? No? Okay. I'll check the chat. We're looking good. Oh, hang on. Why doesn't the term fiduciary apply? That's a question that's been presented. Yeah, so fiduciary is a particular legal term. It defines the highest duty someone can owe another person, and it's a legal term. And what we know is that these statutes, the ones we just went through, the Condo Act, okay, Kiowa, those statutes specifically tell us what duty of care a director has, and they specifically do not mention fiduciary duty. They used to under the Condo Act. So directors of community associations elected by the unit owners that are not appointed by the developer don't have a fiduciary duty. They have some lower duty. It's still a serious, real thing. You can't just show up and drink 5 glasses of wine and take a vote and leave. What I'm trying to say is it's not a fiduciary duty, but it's somewhere just beneath it. And it's a serious actual duty, and you meet it by following the law, following your governing documents, doing your diligence, being informed, relying on professionals, okay? These are some of the basics to meet that duty. So I hope I've answered your question about the specific fiduciary duty. Laws that govern associations. Let's start with condominiums. Condominiums, I think this is super interesting stuff. Condominiums are creatures of statute. Has anyone ever heard that term or that phrase? Well, if you think about it, would you have a condominium unit without the Condo Act or the Horizontal Property Regimes Act? Without the law, there'd be no such thing as a condo, really, because think about Ted Turner's ranch in Montana. It's 100,000 acres surrounded by a fence. That's what we think about typically as real property. But a condominium unit, which is essentially just a box of air and a shared interest in the common elements, you can also get a mortgage on that. It's also bought and sold by deed. It is real property. The reason why it's real property is because the statutes exist and tell us This is how you create a condominium. So we call condominiums creatures of statute. Now, the old act from 1963 to 1990, any condominium created during that time subject to the old act, although some of the provisions of the newer laws apply. What we call the new act, the Washington Condominium Act from July 1st, 1990 to July 1st, 2018, any condo created during that time, it's a Condo Act condo. And then the newish, I used to say new, I guess it's just sort of newish now, the Washington Uniform Common Interest Ownership Act, WU-Kiowa. That's the new consolidated statute. So any condominium or homeowners association created after July 1st, on or after July 1st, 2018, is all in with WU-Kiowa. Okay, so these are just laws, and you can figure out which apply. And I'm not going to get into too many details other than generally those are the time frames. And then you go from there, getting help from your lawyer and manager. Okay, we've also got the Washington Nonprofit Corporate Act. So almost all associations are nonprofit corporations. Let's see. Let's talk briefly about HOAs, non-condominium HOAs. Got the HOA Act, 6438. Again, WU-Kiowa for associations, non-condominium associations created after July 1st, 2018. Let me back up real quickly to clarify a point I made that there's a question. So to confirm, condominiums are only subject to the RCW laws that existed around the time they were constructed. That's not true. Generally, that's true, but they're also subject to some of the newer laws. Okay. For example, the Condominium Act has a provision in it, 6434-010, that's called applicability. And it makes certain provisions of the Condo Act applicable to the condominiums that existed before the Condominium Act. Likewise, WU-Kiowa has provisions in it that say no matter when you're created, you're going to be subject to these particular provisions going backwards for events and circumstances that happen after July 1st, 2018. So there are other laws that apply, even to the oldest associations. Generally, the act applies sort of around when you were created, but certainly the new laws apply in certain respects. So don't forget that. We've got the Washington Nonprofit Corporate Acts. Can you see my mouse pointer? Real property covenants. A covenant, in CC&Rs, that's thought of in HOA as a covenant, is a written promise recorded to do or not to do something, usually for the benefit of other properties. I think of it as they similarly burden and benefit each property. So while your neighbor can't paint their house lime green, maybe you can't park your RV in your driveway, and maybe you'd like to, but right, it's a give and take. They similarly burden and benefit each property. Okay. Let's talk about other laws. Make sure I didn't skip a slide here. Yeah. Okay. Other laws. Let's not forget. We have these specific laws about associations and condos and so forth. We've also got the Telecommunications Act that governs satellite dishes. We've got the Fair Housing Act, right? If someone is disabled and asks the board for reasonable accommodation to keep a lizard or something, and you've got a no pet rule, Fair Housing Act. The Americans with Disabilities Act applies to public spaces. If you've got common use areas or commercial mixed use areas, common spaces open to the public, ADA. Landlord tenant laws. While the association is typically not a landlord, sometimes you might own a unit and lease it, but some of your owners lease. And so to know the relationship between an owner and their tenant, who is a resident at your condominium, That's landlord-tenant law. Building codes, governor's proclamations. That's been the thing that's kept us busy for the last, I want to say 6 months. It's been almost a year, I mean, so the governor's proclamations, and then case law. How are these different statutes litigated, interpreted, and challenged? And they change from time to time, but that's my job, not yours. But what it's your job to know is that this is the landscape in which you operate as a director. You're not expected to be a lawyer, but you are expected to at least keep in the back of your mind, if someone comes in and says, I am disabled, I need a closer parking spot or whatever, you can remember, oh, wait a minute. Yeah, FHA, let's call our attorney or let's talk to our manager. That's why I bring that up. It's just knowing is half the battle, which got me thinking, I said at the beginning, I really like giving this seminar. One of the reasons why is these topics, these basics, I would say 60 to 70% of the problems I see are in somewhere related to a board member's either lack of knowledge or ignorance of or disregard for the basics, right? I feel like education on the basics is a way to solve the greatest number of problems. It might not be the most interesting, but from where I sit, and I've represented hundreds and hundreds, maybe 1,000 associations over the last dozen years. There's so many problems that can be solved by knowledge of the basics like this. And so I'm excited about them. Just try to remember, oh, this applies. Again, you don't have to know the specifics. I just encourage you to try and remember, oh, I heard that mentioned. Let's gather some more information. Let's look into that. Okay. Talked about the duties of a director basically, very generally. Now we're talking about the building blocks, understanding, putting some of those duties in context. First one is, hey, what laws apply? You don't have to know the law. You just need to know of it generally. And now the governing documents. So usually in a room when I'm walking around and talking about this stuff, I'd ask, what are your governing documents? I'll just pose that as a hypothetical for now. What's in them? Where are they located? What is their order of importance? Have you read them? Raise your hand if you've read them. I'm going to check through the screens here. All right. I see some hands. Good. For condominiums. Let's see. Oh, good. The condominium declaration. Where's that? It's recorded. Recorded in the real property records of the county in which your condominium is located. Survey map and plan, same thing, recorded. And in fact, the basic legal requirement to form a condominium is recording a declaration and survey map and plans. A condominium is created upon the recording of those two things. Then you've got articles of incorporation, bylaws, rules, and regs. Okay, the articles are filed with the Secretary of State. If you don't have a copy, check with the Secretary of State. Bylaws, they're usually somewhere in the association's books, although sometimes they're recorded. That's an exception, not the rule. Rules and regs, typically those are in the books and records of the association. For all of those, 1 through 4, check for amendments. For the rules, make sure you've got all your, the current version, any resolutions. And I encourage each director, make a binder. Make a 3-ring binder. Like I've got 500 of these. I use them so that you've got your declaration, all the amendments, your bylaws, any amendments, rules and regs, articles, okay? And then you can go through and highlight or tab them and work with them. HOAs. Sometimes it's called Declaration of Covenants, Conditions, and Restrictions, sometimes just the CC&Rs. also recorded. Plat maps, set a survey map and plan. Sometimes these are called plat maps or surveys. Again, recorded.
Dave, it looks like we might have a question from Richard.
Okay,
I don't know if he wants to unmute
go ahead.
to ask. In the meantime, did you get a chance to respond to the question in the chat about to confirm condominiums are only subject to the RCW laws that existed around the time that condominium was constructed? You did? Okay. I didn't. Yep. I was too worried about noise. The other thing while I have you is you may, if we have the audio issue again, you may want to just turn off your video. Sometimes that helps with the streaming if your video isn't going. It shouldn't affect your PowerPoint, but just a tip. Right now we're fine, but I just want to bring that up. Okay.
All right. Does Richard want to ask? Michelle, can you unmute?
I can. I just don't.
Yep.
He's not unmuting, so I think
I asked to unmute.
Yep.
All right.
No. So I've just written on the chat. I was putting up my hand for, you know, for having read the governing documents, not for.
Oh,
yes.
gotcha. Okay. Thanks.
Okay.
I was a little bit.
So HOA is very similar to condos. It's the contents of the documents may not be, but similar. Covenants, plat maps, articles, again with the Secretary of State, bylaws, rules and regs, check for amendments. And at the bottom here, is there a master association? Are you a master association? It's not uncommon for someone in a home to be, you know, in their subdivision association, part of 9 neighborhoods in a giant master association, or a condominium within another community. So they have 2 sets. They might be in a condo association and in a master association. And there's boards at each level. Let's see here. Okay. Articles. Let's just talk briefly about what they are. Establish the association as a corporate entity. There's not a whole lot of governance in them, typically. It's not going to tell you how to run your meetings, for instance. A couple of things on articles. Sometimes it can be useful to read the articles because they'll give you a particular purpose. The purpose of your association will be set out in your articles, and sometimes it's very eloquent. Sometimes you'll find some things, the purposes for which your association is established that you didn't know about. There might be peace and tranquility. There might be something in there about security. You never know until you read them, so I encourage you to read them. One of my pet peeves is I encourage you to use your correct association name. Often it gets shortened to, you know, Wavecrest Condo Association, but it might be Unit Owners Association of. So, you know, and the particular, you know, if it's apostrophe S or S apostrophe after owners, make sure you know. I think it's professional. It's a good look for the board when you're communicating with owners to use your correct full reference to your actual association's corporate name. Bylaws, typically the declaration controls over the bylaws unless the declaration says differently. Often what you get in the declaration is something that says officers and directors of the association will be as provided in the bylaws, in which case there's your direction to look to the bylaws. Sorry, let's see. Rules and regs. A little bit about what authorizes them. For condominiums, they're authorized by the statutes, the Condo Act and the new WCIOA, unless the declaration provides otherwise. So the board can adopt them by resolution, but sometimes what you'll find in your recorded declarations, or maybe the bylaws, is something about, you know, you got to have a meeting and you got to give owners notice, or some particular procedures on how they get adopted, but the power to adopt them is pretty universal, pretty basic. Again, same for HOAs. Rules and regs should supplement, not contradict the declaration. or your bylaws. You're aiming to control the day-to-day guidelines to promote good behavior, safety, procedures like ACC applications, and association harmony. Keep people from, keep people sort of at peace, and by controlling noise or some other day-to-day things that can really annoy association harmony or destroy association harmony. And a tip here, when you've compiled your governing documents into a binder, my suggestion is, and this is what I've been talking about this for a decade now, go through it with a couple of different color highlighters and look for areas in your declaration that say the board may supplement this section by rule, or the board shall adopt rules regarding whatever that might be. You look for, in your declaration, look for provisions or sections that say the board shall, and highlight it in one color, or the board may, highlight that in another color. And the third color is where it specifically directs the board to adopt rules to supplement that section. We've got a chat. I have a question from Maggie, and it says, are CC&Rs the same as rules and regs? No, no, and that's a great question. I'm so glad you brought it up. Yeah, if you mean the rules, refer to the rules. If you mean the declaration, refer to the declaration. If you mean the bylaws, refer to the bylaws, the corporate bylaws. They're not all rules, okay? And so that's a great question, and very important tip for directors, so that when you're talking to one another, you know what you're referencing. If an owner breached a rule, rule 1.5, you don't mean declaration section 1.5, you mean rules 1.5. Keeping that straight could avoid a ton of confusion. So I appreciate that comment. Okay, roles and governance basics. We have a few minutes left before there's supposed to be a Q&A. I've got a few more slides. So what is a board? How does a corporation take action? Because you are a corporate board. I mean, you're not Microsoft's corporate board, but you're a board of a corporate entity. And like a big giant, public or private corporation or public corporation that's traded, similar business has to take place, and it's done through a board of directors and appointment of duties to managing agents and managers, and it's just a microcosm of bigger corporations. What actions may a board take? What is the board's role? What role do directors play within it? Is there a difference between a director and an officer? May a director vote by proxy? Is it one vote per director? I'll answer those. Yeah, it's one vote per director, and a director cannot vote by proxy. There's a difference between an owner's vote in the association for things like electing directors, right? Or amending the governing documents. Those are association votes. Board and an owner could vote by proxy typically for those types of things. But at a board meeting where the only votes are going to be votes of directors, a board vote, director can't vote by proxy. Okay, just some basics here. The board is the control group of the corporate entity, the owners association, the corporate entity. The board's role is to administer the association on behalf of its members and according to the governing documents. The board must act in the best interests of the association. I believe it's presumptively in the association's best interest to follow the governing documents. So there you have it. When a few slides ago, I said, newsflash, you've got a user's manual. And I see this create so many problems for directors who get tied up with, we want to do the right thing, and this doesn't feel like I'm doing the right thing. Oftentimes, you can just following your governing documents will lead you to what you need to do. It may make one owner mad and the other, it may not make everyone happy. And I know that's generally what directors in human nature, we want to make everyone happy. But following your governing documents, your duty is to the association, not individual owners. The director's duty is to act in the association's best interest. It's pretty good rule of thumb that presumptively it's in the association's best interest to follow your governing documents. And then, yeah, so we've covered all these concepts. Basic board roles, probably not telling you anything you don't know here, but these are the basics. Maintain, repair, replace common areas, and make sure owners are taking care of their units. Collect assessments, pay bills, save for reserves. Maintain insurance. And govern. Enforce the governing documents. Follow the governing documents. If anyone can think of any others, shoot me a chat and I'll revisit this. Let's keep plugging away here. I don't want to miss anything. This is an important concept and one that causes some confusion sometimes. If you think about what actions the association can take, if you think of it like the board can take almost all of the actions on behalf of the association, except those ones that are specifically reserved to owners. Here's a list of actions that are commonly reserved to a vote of the entire membership. Okay. Let's see if this is any different. The entire membership, typically amending the declaration or covenants, that's a full association vote. The board would decide, hey, we should amend it, propose it to the owners, but it takes an owner vote. That's reserved to the owners. Adopting rules, that's typically reserved to the board. Electing and removing directors, that's something that's squarely in the owner's hands. The owners elect their representatives to act on their behalf, right? Electing or removing officers, that's sometimes a tricky one. Usually the officers are selected amongst the directors, by the directors, not by the owners. The owners elect the directors. Typically, I'm not saying always, but typically, it's the directors amongst themselves decide who's going to be president, who's going to be secretary, and so forth. Does that make sense? Filing a lawsuit. Typically, that's up to the board. It's not an association-wide decision. There can be variances. I've seen some declarations try to limit a board's ability to file suit with some voting requirements. That happens, but generally. Removing officers. It's kind of a trick question. Typically, that's the board. The board says, we don't like this president. The board can get together and put a new president in. But removing directors, the board can't say, director, you're off the board, typically. That's usually an owner vote to remove a director. Is this making sense? All right. Here's a kind of a framework for basic governance. Identify an action or an issue. Read your governing documents. Attempt to follow the governing documents. If you don't understand, ask a manager or an attorney. And step 5, repeat. It's somewhere in there. I should have put in gather information. This is a bit simplified. It was to make a point that almost all the answers you're looking for are right in your governing documents. Often that's the first. When my phone rings with a manager or a director, the first thing I do is reach for the governing documents almost every time. Just so you know, like that's such a big part of what I do as an attorney is, well, let's see what your governing documents say. And often there's interpretation issues where I don't know what this means, and that's why they call me. And I've seen it 100 times and I can give some perspective. But your first instinct as a director should be to reach for your governing documents. or to ask questions, to be curious, to get all the information, okay? Some more governance basics. A question I always ask my my board sometimes is, hey, do you even need a meeting? Do you need a meeting for this? Do you need a meeting for what you want to do? Maybe not. Okay. Second, if you're going to have a meeting, are you ready for the meeting? Do you have the information you need to make the decisions you want to make? Have you given proper notice? What's your quorum of directors? Okay. Do you need any input to move forward? Earlier, we talked about how does a director satisfy their duty of care? Ordinary and reasonable care, reasonable per person under same or similar circumstances, whatever it might be. One component of meeting a duty of care for any of them, fiduciary or any duty, any level, is information. Have you done your diligence? Do you have the information you need to make an informed decision? And if not, you need to figure out a way to get the information before the meeting, or share it or review it, that kind of thing. Pretty simple. Does anything need to be done before the meeting? Do you need to request bids? Do you need, what do you need to lay the groundwork? Are you going to give time for owner input? Do you need an executive session? These are just some basic questions. Are you going to be considering advice from legal counsel? Would you need to adjourn to executive session? That type of thing. Okay. Now under WCIWA, remember there's requirements to notify owners of board meetings. Okay. So I put that statute in here. This is a sample resolution. It doesn't mean anything, but it gives you an idea of the process I think about. So a board takes action on behalf of the association by resolution. A board makes a decision. A board makes a resolution. I've drafted 500 of these for, very detailed resolutions about major repair projects to something as simple as, granting a parking space or approving something, or, whatever it might be. But I provide this not as a template, but as just a simple example of how a board thinks through an issue and puts it in paper in a resolution. So first you've got your meeting. What is it? It's a meeting. When? There's the date and time. Hey, we gave notice. We had a quorum. Whereas here's the problem. Here's the issue. Skylights. Why is it a problem? Well, they're important, this process, and it's an issue that matters because we put holes in our ceiling if we allow them. So it's important. And then I like to identify the problem. I like to identify the board's power to act. So here, roofs are common elements. This is a made-up provision. The board regulates common elements. Here's why it's important. Here's why the decision falls to us. Okay. And then what advice have we considered? The board requested and received legal advice, and the advice of an architect. Now, therefore, we resolve as follows. We may approve it on a case-by-case basis, subject to rules and application procedures attached here too. So this resolution does a number of things. It identifies the problem. It identifies the board's power to act. It identifies what diligence you've done. And it also, by way of incorporation by reference, adopts what you can't see here, an attached skylight installation policy or whatever you may have wanted to adopt. That's what this does. And boy, if it was challenged and you had something like this to show, hey, we did our diligence. We thought about these things. We made informed decisions. This is kind of how that looks. That's why I included it as a slide, even though I realize it's very tiny and hard to read and goes against the rules of clear and simple presentations, but I put it in anyway. This is our last slide. Whoops. Okay. I'm going to save that question till the end, Diane, and which is in just 1 minute. So let me just do this last slide and then we'll do questions. Common trouble areas. This is just I brainstormed. Where do I see the most problems? Which for you means might mean as a director, maybe I give this some extra thought. Maybe we make sure we've got a quorum at this board meeting. Maybe we do our diligence a little bit more. Maybe we review the declaration provisions about this problem before we meet. When these are the issues, these are the types of things that cause the most issues. Common trouble areas. Meetings. On meetings, I'll just say this. It's hard to control, especially association meetings. It can be hard to control, and you can't sometimes know what owners are going to do when they show up at a meeting, right? But what you can control is giving proper notice. So I encourage you to control the things that are within your ability to control. Like, have you given notice far enough in advance? Have you put the things on the agenda that you want to cover, right? When you're talking about money, you want to do things right because people are touchy about their money. Records requests, I don't know how to avoid them, but that would be a whole nother seminar. I'm just telling you, it's a common trouble area. So if you've experienced trouble with records requests, you're not alone. Committees, properly constituted committees, use of committees. I'm just telling you, that's another whole seminar, but it's something to think about. Don't just willy-nilly appoint committees. Think about, look in your bylaws. Does it say what committees you're supposed to have, how you're supposed to constitute them? I'm putting it in here just as a marker for you to do additional thinking about that topic. Warranties and defects, don't ignore those things because they can be time sensitive. Amendments. If you're going to amend your recorded documents, call a lawyer. I don't care if you call me, just call a lawyer. It's something that once you record it, it's there for all posterity. So it's worth spending a few bucks to get to have amendments drafted. Enforcement, obviously, collections. These are just big topic areas that are just to try to familiarize yourself with the topic areas, to familiarize you with the topic areas that we worry about and that we see. Collections, and then when should you seek legal advice? When should a director or manager seek legal advice? I don't have a rule of thumb for that, but I can tell you that in the event you receive a legal threat, that's one or a demand letter from a lawyer. When you're dealing with other people's money and you have questions about how to properly assess, that's another time. But I get calls for all kinds of different reasons. Basic quorum questions, all the way up to, boy, we had a leak, it damaged 5 units, what do we do? So yeah, that's all the slides I've got. Now, while my audio is still working.
Yes, we can hear you.
Can you hear me?
Yes. You want to stop the PowerPoint?
Yes. I'll stop sharing my screen. I don't know how to stop sharing the screen. Oh, I do. Maybe that'll help. The question is, let's see. The difference between a condo association versus an HOA. The question is, the comment is, I thought that those terms were interchangeable. Well, the difference is a condo association is not an HOA. I guess an HOA could be a condo association. Those are really just imprecise terms. I suppose an HOA could mean a non-condo HOA or a condo. There really is no good definition for either of them. Sometimes they're interchangeable, but you wouldn't say an HOA, a non-condo HOA, you wouldn't call that a condo association. A condominium is a particular kind of thing. Does that help? I guess I would encourage all of you to try to speak precisely. If you're talking about the declaration, refer to the declaration. Bylaws, refer to the bylaws. Rules, refer to the rules. If you're going to call yourself a condo association, you want to be a condo. If you're not a condo, call yourself an HOA. That's fine.
So
That help?
Dave, can I add to that just for a second? Because oftentimes we get people emailing us that say ABC, COA, HOA, using the same terms in there, and you can't be that in your legal name. So that I think is oftentimes a confusion for folks as well.
Yeah, I've been crusading on that for a long time, and it hasn't seemed to help. But yeah, that's the difference. A condo can be an HOA, is an HOA. It's a homeowners association, but we call it a condo association. Homeowners association that's not a condo can't be a condo. If you've got a particularly thorny issue or complex issue, it's sometimes good to draft a resolution. I'm often asked to draft resolutions for complex issues, if that helps. If it's just if it's a simple thing like, hey, we're going to approve this contract or something, you can do it by board vote. That is a resolution. You just want to make sure it's in your minutes. Okay. You record the board vote and the outcome of the vote in the minutes of the board meeting. And that's, listen, that is effective and legal. And if you're doing something like a big special assessment, sometimes it's good to do that by way of a resolution so that you've got a little more background and cover in case it's ever challenged, I guess. And sometimes, like for a major repair, probably the biggest, most complex resolution that I work on, there'll be a number of different provisions in the declaration that through the use of a resolution, a written resolution, we clarify. Raise and dismiss issues, raise and dismiss issues, raise and dismiss issues. Talk about, why you want to do it, the powers to do it, and then you make your resolutions. We approve going forward with finding lending. We approve the special assessment for ratification by owners. If it's a multi-tiered thing, sometimes it's good to lay it out. But I'm not saying you necessarily have to have written resolutions. Sometimes boards find them to be useful tools. I have another question from Jill. Do co-ops fall under different RCWs? Answer is yes. That's all I have to say about co-ops. Currently I don't think I represent a co-op. So thanks, Linda. Let's see. He says very informative. Okay, sorry. I think it's important to distinguish because the law governing condos is different than HOAs. Totally agree. If you're a condo, you've got the condo laws. If you're an HOA, for years you've had the HOA Act, 6438. Now, however, Wakiowa applies to both. So there's some standardization among condos and HOAs. You're going to be a community association, common interest community association, I guess. Let's see. Another question, are there any suggestions for encouraging owners to volunteer for the board? Giveaways, drawings, bribes, I don't know. I've seen my clients try a number of different things. 8-unit association with 3-member board, and we really struggle with filling director positions. In all seriousness, if you can find a way to streamline and organize the business of the board, it can make it much easier to find volunteers. Where if you say, listen, for the most part, we have to meet twice a year, that kind of thing. And at that meeting, we're going to appoint an officer that is empowered to do all the banking and blah, blah, blah. There are ways that you can, in a smaller association, you can streamline what's required to make it easy for folks so that you can at least get a quorum and do the business of the association, right? So that's one way I would suggest. Another way, I mean, hopefully just peer pressure and guilt trip, say, listen, we're a small association. I can't do it all. It's important work. That's one way. Question, can you expand on that comment about appointing one member to decide on financial matters? Oftentimes in your bylaws, you'll have provisions that allow you to appoint officers, right? And so there's a board. Think of the CEO of Microsoft or Google, right? They've got, that's not they may be CEO and chairman of the board, they may be a board member, but certainly for all the day-to-day activities they're doing, they're not going back to the corporate board of Microsoft once a week to get a board resolution on each little decision they have to make. Similarly, if you use your officers, there's ways probably buried within your own documents that that officers are given powers to do certain things between board members to manage the affairs of the association. You don't necessarily have to have as many board meetings. That's kind of one avenue you might want to explore. I'm at the end of the questions. I'm also at 5 minutes over time. Are there any other questions?